It's one of the early murder cases in Herkimer County history, at least that we have records of. And as you're going to see, it's a kind of a provocative case, a very tragic case, very unique case. And I kind of titled it Between Two Stools because the perpetrator, John Bowman, by age, by time period, he was always kind of like falling in between the cracks here. You know, if this had occurred, as say, in an earlier time period, things would have turned out much differently. A later time period, also differently. Had he been older or younger, things would have turned out differently. So let me get to the case itself. Oops, I don't know why that's not working. There we go. All right. This is how I learned about the case. And the headline of this article makes it sound a little bit more, you know, I don't know what the word I want to say is, a little more bigger than it is, but, you know, secret room located during Reconstruction. What this referred to is, it was a reprint of an article by Paul Draheim, who was, you know, a Telegram reporter and Herkimer County historian at one point. And he was relating a story in the 1980s of something that had happened back in the 1930s. And at the Herkimer County Courthouse, the old one that's on the corner in North Main and Court Street, apparently they were doing like a WPA project and doing some refurbishing, and lo and behold, sometime in the late 1800s, they'd removed a staircase, and when they did, they accidentally kind of disconnected or easily disconnected a room from the rest of the courthouse. You could still reach it, but you had to go through a trap door in the attic, or you had to go up to like the belfry and walk on boards across. But they rediscovered that they left stuff in this room, and there were a lot of old court cases in it, and one of which was this John Bowman case. And what made that case so kind of unique was the fact that the murderer, well, at least was listed, believe it or not, as a 9-year-old boy, and his victim was a 4-year-old girl. And, you know, I mean, today that would be like nationwide news probably, but back then, well, it did kind of make its way around the country a little bit. But it was just, I say, these old court records, not that there were, you know, a lot of detail to them, but this is how I learned about the case. And then, I don't know, it's been about 10 or 12 years ago, I was trying to work on a PhD at the University at Albany, and I needed a topic for a paper in a public policy course. So I'm like, well, I want to dig more into this case. And there really wasn't much to the records, but I wanted to find out more of what I could. And one of the things I found was an actual news article about the case. And yeah, the original newspaper that this was in was probably the Herkimer Democrat, and all of those newspapers are gone. You know, fortunately, at least for the records, you know, this story was reprinted in other newspapers. I think this one came from a newspaper in Shenango, but they all kind of attribute it back to the original Herkimer Democrat. And as you can kind of see there, if you're trying to read it, you know, it starts, you know, published on the 4th of July, which happened to be a Thursday that year, and this is the year 1811. Is like, yeah, we do not recollect having seen a more wicked and diabolical deed in the annals of history than the following. On Thursday last, which would be June 27th of 1811. It said, John Bowman, a boy of about 11 years old. Now, his age, as you're going to see in this program, it's a little bit uncertain. Even at the time period, it seemed to be a little uncertain. But apparently he was living with a family of Mr. James White, and I'm not sure why he wasn't living with his own family. Whether he was an orphan, whether he was, indentured out, I don't know. But he was living with this family headed by James White, and he apparently murdered their daughter, Anne Eliza White, a girl of 4 years of age. At least her age is pretty consistent in the records. And it said he decoyed her to the bank of the river, which would be the Mohawk River, where he procured himself a club, beat her on the head till her skull was broken and her face lacerated. And then after killing her to conceal the body, he hove it into the river. It's an old 19th century word there. And then deliberately went to the house and ate his dinner. When the child was missed, he denied knowing where she was, and about 4 hours later, they found her still in the river. The local coroner was summoned. Back then, a coroner could assemble a group of citizens, which is what they called a coroner's jury, who gave the verdict of willful murder. Basically meaning it wasn't accidental, it was intentional murder. So this is part of why I said, or gave the title of this as Between Two Stools. The two stools here were his ages, according to law in the early 19th century, if someone was the perpetrator of a crime and they were over the age of 14, the law said you were, reasoning as an adult and you would have been treated as an adult. All right. If you were under the age of 7, it was assumed you couldn't, form criminal intent. You were still too much of an infant. So he's like right in between. So society didn't quite know what to do with, a presumed 11-year-old as a murderer. And the thing was, in the early 1800s, there's no special treatment for murder of anyone of any age. The punishment was automatically the death penalty. All right. So again, his age or his time period is kind of unique there. Reforms for age might not come in consistently for a number of generations yet. So, after 4 hours after the murder occurred, they found the body, they called a town constable. He was committed to the Herkimer County Jail. And it took about 15 months until his trial could happen. When he committed the murder on June 27th, the Court of Oyer and Terminer, which basically is, old language for to hear and determine, it was a state court that made a circuit around the state, and they had just been to Herkimer County earlier that month in June, and they usually came about once a year. Typically, it was about a year until they came back, but it seemed in 1812 they didn't come back until September. So he had a very long wait for his trial, and all that time he would have been sitting in the Herkimer County Jail. The very first Herkimer County Jail. We're just about finishing the fourth of Herkimer County's jails in history right now. But the very first one was built in 1793. It's approximately where the old courthouse is in Herkimer today, if you're familiar with how Herkimer is laid out. And it was a combination jail and courthouse. They put it all in one building back then, and it wasn't a great jail or courthouse. It wasn't exactly well constructed or well thought out, especially by modern standards. The jail was on the first floor, and by what few records exist, it was a very small, cramped, dirty facility. On the first floor, there was a debtor's apartment. So if someone was arrested for, owing debts, they threw you in jail, but a unique thing was they let you out of jail during the day as long as you stayed on Main Street, so you could hopefully find employment on Main Street, and you had to come back to the jail every night, but you worked off your debt back then. So that's what a debtor's apartment was. There was the jailer's residence and a workspace, and then there was 2 large cells for prisoners. And that was all the prisoners. So that could have been drunks, it could have been murderers, it could have, yeah, they just threw them all into these 2 cells. The courtroom was up on the 2nd floor, and according to some records, I don't know how often, or probably it wasn't very often, that they cleaned the cells on the bottom floor, but there was enough odor from those cells that they said it left the courtroom on the 2nd floor smelling, quote unquote, obnoxious. And it was pretty much a ramshackle jail. In one of Herkimer County's histories, I think the one written by George Harden, he said about this jail once that it really was only good enough to confine what he said was paralytics. And that was pretty much about right. This was one of the, what you're seeing now is one of the other very short histories of this case, written by a man named W.H. Tippett, who wrote a book about Herkimer County murders back in 1887 at the time of the Roxelana Drews case. He didn't write much about this John Bowman case, but one of the things that he said, and I can't find it in any other source but his, but I've got it kind of highlighted there with arrows. He said, Bowman, before his trial, was confined to the old county jail, and to the great surprise of the jailer and sheriff, he turned up missing. So in these 2 cells that they had, suddenly he disappeared from them. And they said a search was instituted, but Bowman was nowhere to be found. It's like in the course of a few hours, however, he nonchalantly entered the front door, and when questioned about his absence, he said that, quote, that he was tired of the jail and simply went out to take a walk. So again, you can tell I don't think he was functioning with an adult's mentality there, or quite recognizing how serious his legal trouble was, but also tells you that jail wasn't very secure. That if a 11-year-old can just walk out the door and then just walk back in, it's not a great prison facility. All right, if you also notice there at the bottom, and I may come back to it near the end of the program, when the Tippett's book was written in 1887, they tried to do some research, and Samuel Earle, who was a judge at the time, said he made every effort to find out about what happened to John Bowman, but he couldn't find anything out about him after 1820. I did find out what eventually happened to him. All right. So I say, it was a 15-month wait for that trial. And it finally got underway September 14th of 1812. And, so John Bowman, except for his walk out the door, had been there this whole time. And finally, he's going to meet the people who are going to take part in the trial. All right. This was the judge of the case, a man named Smith Thompson. And you're going to find out a lot of people related to this case, they're all connected to each other. All right. He was a former member of the New York State Legislature. He was a former district attorney. And since 1801, he'd been an associate justice on the New York State Supreme Court. All right. So that's the judge of the case. I couldn't find a picture of the district attorney, but he was also of note. He was a former U.S. congressman, a very prominent figure in the politics of Utica, which was nearby, of course. And he'd been a district attorney, working on the circuit, for over a decade at that point. All right. This was John Bowman's defense attorney, a man named Daniel Cady. All right. He also was a member of the New York State Legislature. He was from nearby Johnstown, kind of in the other direction. Very prominent attorney. People knew him throughout the state, not only as a state legislator, but also as a jurist. In fact, he had just finished handling a case where he defended someone against the charges of trying to bribe the Speaker of the New York State Assembly. And one of his co-counsels on that was Aaron Burr, who had just returned from Europe after he kind of had to leave following, well, being accused of treason. That's a whole other story. And as my best guess is, Daniel Cady must have volunteered to take the Bowman case, because there's no way an 11-year-old or so is going to be able to afford an attorney of that caliber. So somebody probably either talked to him, said, can you help out here? Or he heard about the case and said, the kid needs some defense, so I'm going to give it to him. But I can't imagine he was ever paid for this. All right, here's one of the few records that was found. These records are in the Herkimer County Clerk's office. The last I knew, they were down in their basement archive vault. And court records back in the early 1800s are very, very sparse. They're not like what you would see today. You're not going to see pages and pages of testimony or anything. It's all very cut and dry. But there it has, the people v. John Bowman, indicted for murder, arraigned, and pleads not guilty. It's pretty much all they say on the first day of all this. I think there was about 4 or 5, maybe about 6 total cases that they all were going to hear. It's been over a year since the court has been through, so a lot of things have built up. If you read that bottom one, that must have been an interesting case too. People versus John Phillips, who was being indicted for bigamy, of all things. And I think there must be 2 John Phillipses, because there's another John Phillips that gets mentioned in the record, and I can't believe they're the same people, because the other John Phillips was the town constable. All right, but so they plead not guilty, and court is adjourned until tomorrow morning at 8 o'clock.
Yeah.
So these are the other records. There's no testimony anywhere, but they give the list of the jurors that were sworn and a list of the people's witnesses. From what I can tell, there were no defense witnesses called, so Daniel Cady must have just basically cross-examined the prosecution witnesses. If you look, there's, down here, there's John Phillips's name. Yeah, and I don't think that's the guy being charged with bigamy. At least I hope not. All right. And actually, if you're reading at the bottom, in the old cursive there, they do find him, John Bowman, guilty. But Daniel Cady, as the defense attorney, as best as I could do with my research, he did try as much as he could to mount a decent defense. I looked up as best as I could in the 1810 and the 1820 census what I could about each of the 12 jurors. And at least 11 of the 12 I could find in one of those 2 censuses. And only 2 of the jurors came from the town of Herkimer. So when they did the voir dire process and kind of weeded out who's going to serve on the jury, Daniel Cady was trying to make sure that all these people, were not from Herkimer, didn't know Bowman, didn't know the Whites, so there was only 2 from the town of Herkimer. The other thing I noticed about the makeup of the jury was, and I couldn't find that guy Jabez D. Wolf in either of the 2 censuses, so I can't say anything about him. But the other 11 jurors all had boys under the age, young boys living in their households. So I think Daniel Cady was trying to find jurors that might somehow identify with trying to raise a young boy, you know, there was a number of jurors I found who had no girls under the age of 10 living in their households. So he was trying to make sure that, you know, you didn't have jurors that would identify with the victim. And I got the sense he didn't have a lot of evidence to work with in his case. Say, there's the people's witnesses, and an Abigail White is listed, so I'm assuming that was the victim's mother. There was James White, who, according to that one article, was the victim's father. There's John Phillips again, who I'm assuming is the town constable that was called to do the initial investigation. There's a Peter Bowman, and I'm not sure how he relates to the case. I know Sue was talking to Jan McGraw there. Possibly he was an 18-year-old cousin of John Bowman, but that's a guess. The other witnesses, I'm not sure about. They could have been members of that coroner's jury. They could have been neighbors. I don't know. But as you can kind of read there at the bottom, very short, it was a one-day trial. You would never see that today, I think, in a murder case. All of the witnesses and all the testimony would have just been given in one day, particularly for, you know, an 11-year-old or so boy. But there it says at the bottom, the jury finds the prisoner guilty, and he was accordingly sentenced to be hanged by the neck until dead on the 4th day of December next, between the hours of 11 o'clock a.m. and 1 o'clock p.m. And that by itself is kind of interesting in the sense of that time period. They didn't wait around to usually they didn't wait around to carry out executions. Well, yeah, when someone was found guilty, they usually were hung within a matter of weeks, if not days. So this trial ends on September 15th, and they're pushing off the execution until December 4th. And so they were trying to buy time. So I have a sense that Daniel Cady and Smith Thompson, the judge, and maybe, Nathan Proctor is the prosecutor, they may have been all trying to work a deal behind the scenes, but the jury basically said, you know, according to the evidence, he's guilty, and the judge is kind of saying, my hands are tied here, you know, by the law, that the punishment must be death, and death by hanging. All right, there was a news article that kind of shows the same thing. And again, you can see the age here. They're still listing him as a youth of 11 for the murder back in June of 1811, and they're still listing Eliza Ann White as 4 years of age. And they're also crediting the Herkimer American newspaper. I really wish I could find those original newspapers someplace, but all of them have been destroyed or lost to history in the last 200 years. All right, so this is maybe why they were trying to buy time. Granted, back then, the punishment for murder was, you know, hanging. But he's an 11-year-old, and even society back then, they're a little skittish, hesitant about executing, 11-year-olds or anybody under the age of 18. As you can see on that list, and and there's a lot of research you can find on juvenile executions. The youngest anyone was ever executed was age 12. And those are 3 right in a row here. And all right, if you're going to execute somebody that young, if you notice too, one is a Native American and the other 2 are African Americans. Obviously, John Bowman is well, he wasn't. And in fact, most on that list, as you see, tended to be African American or occasionally Native American. So there was some hesitancy there about hanging, someone that young. even though they had committed murder.
I agree that there's a lot of.
Yeah, well, and this
That's all
was from like 1642 up to 1864. So, and they are kind of spread out among the different states. All right. So this is why they may have postponed the execution for about 3 months or so. Because the New York State Legislature was scheduled to come back into session on November 1st of 1812. Now, under the New York State Constitution at that time, the governor did not have the power to commute sentences or pardon anybody. They just didn't have that in the state constitution. However, the legislature could, commute a sentence or pardon, by statute. And so what Smith Thompson did as the judge was he wrote a letter to the governor, which would be Daniel D. Tompkins, kind of asking the governor, it's like, can you bring this to the state legislature, when they come back in session, all right? Now, as you can kind of see there, this was the original letter. I found this at the State Archives in Albany. And why it's so charred was there was a pretty severe fire back in 1911 at the State Library, and a lot of New York State's old records were burned. They tried to save as many as they could. And, this was at least part of the records that they found. And you can see John Bowman's name right there, female child. You can kind of work it out. Fortunately, the entire letter was republished in the newspapers at the time. So we have the whole letter, not just the burnt fragment of it. But there's some interesting things about this letter. One, it's misdated. It should be 1812, not 1811. Because the trial hadn't even happened yet on November 1st, 1811. All right, and there's Smith Thompson's name, and it's to His Excellency the Governor. Again, consistency on age of the victim, the female child between 4 and 5 years of age. But then there's something very kind of striking about the letter. It's like, and he's talking about John Bowman here, who perpetrated it in June of 1811. Which time the convict was but little more than 9 years of age. Somehow he's de-aged by 2 years. And I'm not sure how that happened. Whether somebody made a mistake, whether they intentionally tried to make him look younger. But right here is the evidence of why they postponed the execution, because the judge comes right out and says this distant day was appointed for his execution principally for the purpose of affording an opportunity of having his case submitted to consideration of the state legislature. So, I mean, they were trying to do something for the kid. But this gives a hint about the testimony that must have gone on at the trial. Because Smith Thompson, as the judge here, is saying, it's like in this letter, it's like, I don't think it's necessary to report to you as the governor the testimony, as I entertain no doubt of the propriety of the conviction. So the judge is saying, I'm totally convinced that this young boy did it. And he tells the governor, hey, if you need, any details, I'll furnish it to you without delay. But he's like, I shall state at present generally that the proof against him was clear and conclusive to establish his guilt. Apparently the governor didn't ask for anything more. He just took Smith Thompson's word for it. Or else those records, if the testimony was sent, it got burned in that 1811 fire. Because I can't find any of that evidence anywhere, either in Albany or in Herkimer. But here it does say whether, however, considering his tender years, it would not be expedient to arrest his execution by an exchange of punishment, and is a question well worthy of consideration of the legislature. So there's the judge trying to intervene on behalf of young John Bowman, can you give him some other punishment besides death? Because as the judge, he's like, I can't do it. All right. And here's where I say a lot of people were connected. The governor and the judge used to be co-associate justices on the New York State Supreme Court for about 3 to 4 years. So they knew each other. And that may be why Smith Thompson said, look, trust me, but also that Smith Thompson knew he had an in with the governor.
5 of the first 6 judges that were appointed to hear those trials are all related.
So here is part of the governor's speech to the legislature. And there's some things in it that are kind of interesting. Well, one, it does say, he's talking about the John Bowman case here, talks, and this is, they say, the governor speaking to the legislature, talking about Bowman being convicted, that the judge, Mr. Justice Thompson at the last court in Herkimer submitted to your immediate attention. The official communication of the presiding judge is now delivered. So either must have read or, somehow distributed copies of that letter to the legislature. And he says, the unequivocal guilt of the convict on the one hand and his tender years on the other make your duty with respect to him extremely delicate and responsible. And then he says, this is the only matter of an extraordinary nature which I shall present or at present press upon your notice. That's kind of interesting because in November of 1812, the War of 1812 had just broken out about 5 months earlier. And New York State had a lot of other stuff going on. I mean, if you read at the top of this, they're talking about people from the state who've been disabled who have fallen at the Battle of Queenston. And then down here, he's like, in the meantime, I cannot refrain, he's talking about the declaration of war. So somehow he just kind of slips the John Bowman case right in the middle of talking about the War of 1812 to the legislature, and it's like, you need to pay attention to this, and and then goes back to talking about the War of 1812. But he did bring it to the legislature, and the legislature was going to try to take action on it. They referred what to do with young Mr. Bowman to a special committee. The committee was made up of 3 people, one of which was Abraham Van Vechten, who had his law office down the street from Daniel Cady in Johnstown. They were both members of the state legislature. They both were lawyers at Johnstown. They both knew each other. John W. Taylor, he and Cady were serving on a committee to give a response to the governor's message. So they knew each other. I'm assuming Elbert Jones knew Cady as well. So it also seems like Cady's kind of like stacking the deck here, is to getting the people that he wants to help his young client. And also, if there was a mistake on, John Bowman's age, Daniel Cady would have been the only one in Albany that would have really known about it. And he's got no motive to set the record straight. If the legislature's hesitant on, executing an 11-year-old, they're going to be even more hesitant to ever think about executing a 9-year-old. All right. So this is what happened. You have an act passed by the legislature. The committee came back. It's the very first law passed by the state legislature in their session in 1812. Say chapter 1, say the very first law passed November 10th, 1812. I mean, it goes down that he was supposed to be executed on the 4th of December. There's the mention of the female child there. The legislature now thinks he's 9. So, that's part of the reason why they're going to be so lenient. Of course, lenient is a relative term for the time period. As you read there at the bottom, what they do is they commute his sentence. And they said, instead of the punishment of death, said John Bowman shall be and is hereby directed to be confined at the state prison at hard labor for and during the term of his natural life. So they sentenced him to life at hard labor at somewhere around the age of 11 or 12 years old. And they tell the Herkimer County Sheriff, deliver him to the state prison. There was only one state prison at the time. It was down in New York City. I'll show you a little bit more about that in a second. But as I say, to keep him there at hard labor during his natural life. So that's what they did. And so this was the only prison in New York State at the time. It was called Newgate Prison. I've seen it also listed as being on Blackwell's Island, but its official name was the State Prison of the City of New York. So Sheriff John Mahan, had to transport him all the way from Herkimer down to New York City. And there were some Enlightenment type reforms that were going on at the time period. They were slow taking hold, and some of them may have been a little bit naive. A man named Daniel Eddy was the, I don't know, let's say the brains behind creating this, a new vision of a prison. So in 1797, that's when Newgate Prison was created. This guy, Daniel Eddy, had this thought, okay, we're gonna try to reform our prisoners. We're gonna give them a balanced diet. We're gonna provide a hospital and a pharmacy in the prison. We're gonna teach them, a work ethic by having a manufacturing center there. They can make tools and nails and barrel staves and things like that. We're going to have a church. We're going to instill them with a sense of religion, even a night school. And we're not even going to have armed guards. There's going to be no corporal punishment. And they actually thought this was going to work out. I mean, it was a noble idea, but what really happened was, I say, 1797, the prison was founded. About 2 years later, they'd already figured out to keep the prisoners in order, you needed to arm the guards. And there was a revolt of 50 to 60 inmates. All right. A year after that, the state militia had to be called in to quell a riot. So I'm assuming the riot was something bigger than 50 or 60 inmates revolting. A mass escape attempt in 1803. So this is what the prison was like when they sent a 11, 12-year-old to it. And while he was there, it didn't get any better. By 1817, the state of New York is saying to the prisoners, look, there's a death penalty if you commit arson or assault on any guard, with any intent to kill. In 1818, when young John Bowman must have been there, the state militia had to go in to put down another massive riot. By 1819, they're like, we have prisoners and put them in stocks and irons, as necessary. So the prison started off with some noble goals, but it did not end up that way. And the other thing about the prison was it ended up being very much overcrowded. When Eddy designed the prison, he was thinking, we're not going to have more than about 450 inmates. According to the records, by 1821, you had not quite double that amount. And I'm not sure why. It may have been economics, but there was a big crime wave following the War of 1812. And this is the only prison in New York State at the time, so they're sending everybody there. And the only way that the state of New York could handle the overcrowding was they just started pardoning the prisoners with lesser sentences. So they were like, okay, that's just, simple assault, or that's just simple theft. We'll let you go after 6 months or whatever. But even then, the prison was very much overcrowded. And there is kind of I want to call it it was a good outcome, at least as a researcher, because so many people were being pardoned and let out. The government had to keep a record of that. And that's how I found out what happened to young John Bowman. I actually found it out through a Google search, believe it or not. I typed in John Bowman, murderer, Herkimer, and it came up on a genealogy website. And the genealogy website was a transcribed version of a list of prison pardons that was at the Dutchess County Clerk's office. And there was his name, and it definitely was him. So how I got a hold of this was, so I wrote the Dutchess County Clerk's office. I told them I was working on a paper as a graduate student, and I'm like, can I see the original record, not just the, and they're like, sure. And so they mailed me a photocopy of the original document, and they were like, just send us back $1. I'm like, okay. I already had the document, but I'm like, I'll be honest. So I got the original list of prisoner. I mean, this is cut down so you can kind of see it there. And I did ask them, it's like, why do you have a record of this? And whoever was answering from the clerk's office said, well, they were probably giving a list of all these prisoners being let out of prison to every county clerk in the state, because they were trying to tell, heads up, we've just let these people out, so they might show back up in your county. And must be at every other county clerks, the records were lost, but they lasted long enough at Dutchess County for them to be transcribed and put on the internet. But this is how I found out what happened to John Bowman. So there's his name, listed as age 20 in 1821. So he definitely wasn't 9 at the time of the murder, unless this is wrong. But place of nativity, county of Herkimer, murder, life in prison, date of sentence, November 10th, 1812, which was the date that the state legislature passed its special law commuting his death sentence. There it was, county convicted Herkimer, and he died February 5th of that year, listed as Typhus. I've tried to look it up online. Fifthus I've also seen. Depends if you want to pronounce it with a British accent or not too. What that is today is tuberculosis, which I can easily see happening in a very overcrowded prison. And that's why, Judge Samuel Earl back in the late 1800s couldn't find out what happened to him after 1820. Well, he died in jail. And this is the only description I've ever found of the young man, fair complexion, brown hair, and he grew to be 5'9" tall. But that's what happened is his sad end. And he was listed as a discharged prisoner because he was discharged by, reason of death. I mean, if you look through the whole list as to why they were let out, many of them are pardoned, but those that do die, are also listed there. And if you look at the whole list, there's quite a number that are listed as typhus is the cause of death. So he wasn't the only one dying of tuberculosis that year. But then I kind of teased some things out. Well, what happened to the other people involved in this case? And this is what kind of, surprised me in some instances. I mean, this young boy, John Bowman, had a very tragic, very sad life, but he somehow interconnected with some very, very important people, almost like a weird Forrest Gump type thing here. Nathan Williams, the district attorney, all right, after the case, he ends up helping to establish the Utica Library. I don't know if it's the same building, but it still exists in Utica today. He ended up becoming president of the village of Utica. Today, you'd call it the mayor, the city mayor. He ended up on the New York State Assembly, the New York State Regents. For a number of years, he became a circuit court judge. And this Nathan Williams, his family is part of the Munson Williams Proctor Institute founding in Utica. So he went on to some success. The governor who, brought Bowman's plight before the legislature. He went on to some success. He ended up becoming vice president of the United States under James Monroe for 8 years. Right? And as I said, Tompkins and Smith Thompson, the judge, knew each other. They both ended up in the James Monroe administration. Smith Thompson would end up as the Secretary of Navy, which was then a very high-ranking cabinet post. And then when there was an opening on the United States Supreme Court, James Monroe actually appointed, and he was confirmed. So for about 20 years, he ended up on the U.S. Supreme Court, serving alongside like John Marshall, Joseph Story, some of the very big name justices of the early 19th century. And Daniel Cady, well, he kind of came in and out of things. He ended up as a member of Congress for a term a couple of years after the Bowman case resolved itself. Then he went back into practice. I don't know if he just didn't like the House of Representatives or he just didn't like politics or whatever. So he went back into private practice for many decades and then finally came back out and served on the New York State Supreme Court while he was in his 70s. But what's interesting about Daniel Cady from Johnstown, and maybe some of you already kind of put it together, a couple years after the Bowman case ended, he and his wife had a daughter named Elizabeth, who would go on to marry a man named Henry Stanton. So his defense attorney was the father of Elizabeth Cady Stanton, one of the most prominent women's rights advocates of the rest of the 19th century. So there you can see Elizabeth Cady Stanton, and that would have been one of the grandchildren of Daniel Cady there. Newgate Prison, where John Bowman ended up, as I said, that was like a black hole of Calcutta. The state finally was like, this is just not working out here. About 7 years after John Bowman passed away, the state shut down the prison entirely and tried again with 2 new state prisons in other parts of the state, Auburn and Sing Sing. And I know Auburn was known for its reforms, kind of a different type of reform system. And, had John Bowman lived longer, not caught tuberculosis, he might have been transferred back to upstate New York. And the first place where he was locked up, the old Herkimer County Jail, that original jail courthouse, that was the one that ended up being destroyed in 1834. Kind of an interesting story there. That was a ramshackle jail from the beginning. It ended up burning down on January 30th, 1834, as it said. The prisoners in the jail, that's the old-fashioned spelling of the word jail, apparently were amusing themselves by setting fire with a candle to some newspapers pasted on the wall, and were unable to control the flames and gave the alarm too late, and a strong wind carried the embers over to burn the church on the other side of the street down too. So that's why if you ever go down Main Street in Herkimer, you've got an 1834 jail and an 1835 church still there at the historic Four Corners. So that 1834 jail that's there now, which was built out of brick so it wouldn't burn down, or limestone, that was there to replace the first jail. And that 1834 jail was left in use all the way up to 1977. So here's just a couple other things. Said had John Bowman been born in a later generation, things would have been different for him. By 1825, the very first detention and reform facility for juveniles was created in New York State. It took almost a century until you got a juvenile court for the first time in the city of Chicago, but that idea then took hold. In 1989, the Supreme Court finally said, no, we're never going to execute anybody in this country under the age of 16. And then in 2004, they raised that to age 18. All right. So that's why I titled this as, you know, two stools, because, you know, he was always kind of like in between here. Yeah, had he been younger, yeah, had he been like a 6-year-old, they might not have even charged him with a crime. Had he been 16, 17, 18 years old, they would have hung him. They never even would have probably brought the case to the state legislature. Or if they did, the legislature might have even balked at, you know, commuting the sentence. As I said, had this happened at the time of the Revolution or you know, French and Indian War or earlier, they probably just would have hung him no matter his age. Let's say later generations, you know, he probably would have gone to a juvenile court and juvenile detention facility. But society had a really tough time figuring out what to do with him in his own time period. Right. So as I mentioned there at the beginning, you know, let's say you can find at least a short synopsis of this case. I've probably given you more detail than what's in the actual book here, but this is the book where you can find the histories of Herkimer County murders from the, I think, late 1700s all the way up to the early 20th century. And so if you ever want to stop by the Historical Society, I mean, it is open. The gift shop is open. And if you haven't ever purchased a copy of this book, you're very welcome to. Or if you're out of state, we can ship it to you.